workshop, SHEQ workshop of AGBIS, and I think having the 8th one is great. It means that we're busy with the sustainable thing here, and I think it contributes a lot to keeping everybody informed and up to date with everything. So Annelien did post in the chat just the attendance form, so please complete that. It's just a way that we can just see who is on and who gets value out of these workshops. And also, Annelien, do you think that this workshop is also accredited for CPD points, if I'm not mistaken? Am I right?
No, we couldn't send it through to Annelien in time, so I don't think it's approved.
Okay, all right. Nevertheless, please complete the form so that we then have it on record. And then a special welcome to Lucinda. Definitely not an unfamiliar face. I think definitely an expert in the compliance field in terms of occupational health and safety and environmental law. So Lucinda, thank you very much for joining us today. So just a bit of background regarding Lucinda. She is the Managing Director at Implex. Implex is a company that does legal compliance consulting and auditing, and they also have a very strong training department, training in various aspects of compliance, legislation, and so on and so forth. So Lucinda, I think from my side, very, very warm welcome. And thank you for taking the time and the effort to share your knowledge with us. I think on this topic, it is a very broad topic. It's a very, very intense topic as well, and I think it's a topic that often is overlooked to a greater extent. So I think just something from my side to everybody that's joined today. Please take the time to take in the information that Lucinda is going to share. I think it's going to add great value. And I think that we're going to walk away here with definitely a lot to think about and go back to our workplaces regarding what we're going to implement and how we're going to drive this process forward. So without further ado, Lucinda, thank you very much, and I'm going to hand over to you. Thank you.
Thank you, Gerard. Good morning, everyone. Don't worry, you don't have to look at me the whole session. You can look at the screen. I just wanted to introduce myself. So I've been told I've got a very calming voice, so I'll speak a little bit quicker than normal, just to make sure you don't fall asleep. I hope that the topic matter will keep, for me, it's riveting. So hopefully you'll find it riveting and it'll keep you awake. As I said, I just wanted to introduce myself so you can see the face behind the voice that you'll be listening to for the next 3 hours. On that point, let me switch off this camera and then I'll feel a lot more comfortable. There we go. What is it they say? I've got a face for radio. Right. This is the second time that I'm participating out of the 8. So for me, it's also a privilege to be here and to share with you what we do at Implex and how we approach these things. The topic for today is environmental law and environmental management, bringing the two together. So as Gerard said, from my point of view, we focus on the legal compliance component. Legal compliance in health and safety on the one hand, and then environment on the other hand. So when we talk about legal compliance in health and safety, we look at the Occupational Health and Safety Act and we look at the COID Act, and in certain instances, we might even look at the Railway Safety Regulator Act, and that's just about it. Now, when we're talking about legal compliance in the environmental sphere, for me, when I look at environmental law, it feels like higher grade maths, or the advanced maths. I'm too old to know what the new one is called, but you get that advanced maths. That's what environmental law is for me, because of the sheer vastness of environmental law. So, we look at the legislation. Usually we have an act or two acts that we have to look at. In environmental law, it's much broader. So, like with health and safety, the starting point is always going to be your risk. So you need to, I thought I switched off this camera. Let's try that again. Now I don't have to watch myself. What you need to do with environmental law is you need to understand what your environmental aspects are and the impact that those aspects have on the environment. So we've got that covered later on in the discussion. And once you understand that, then you can go to the legislation and you can say, all right, what part of this legislation applies to me? So I think that's a good starting point. You'll see if you look at the program, what we've done with the program is we've broken it up into questions. And under each of these questions, I'm going to nitpick from the legislation and I'm going to say to you, all right, we need to look at this or we need to look at that. So our first question is, what acts and regulations do I look at regarding environmental management as a SHEQ practitioner, safety, health, environment, and quality practitioner? So if I'm looking at the legal part, now, if you've got a system implemented, like your ISO 14000, perhaps, which is your environmental management system, you will notice that one of the elements of a system is legal and other requirements. And under legal and other requirements, they talk about identifying the laws that apply to you. And then the second component is measuring your compliance. Now, in our work environment, identifying the laws that apply to you, we do that through something called a legal register. So a legal register, it's one of the things that we do at Implex. Typically, a legal register is like a company-specific law book. So we would put in your legal register, we would put the laws that apply to your operations based on your impacts and your aspects. Right now, I can say to you that if we look at it from an environmental point of view, there will probably be at least, if you look at national, provincial, and local, at least 20 different pieces of legislation that might apply. So just to put the broad framework there. Now, once we understand that it's not just one or two acts, it's a whole bunch of acts. Now, of course, I need to break this down, and that's what I'm going to try and do next. So if you know me or if you've ever listened to anything I say, I always start off with the body of law. We need to understand the body of law because if you go onto Google and you Google environmental acts, you're going to find the National Environment Management Act. You're going to find the Waste Act. You're going to find the Air Quality Act. But what you need to understand is that that's just the starting point. When you look at legislation, we talk about the body of law, and the starting point of our body is going to be an act. So an act is the principal legislation. So that's the key thing. So if you compare it to health and safety, there you have the OSH Act, and then the OSH Act has regulations, and then there's norms and standards. In environmental law, we have a family of acts. So not just one act, but a multitude of these acts. So that means that there's a whole bunch of bodies in our family. So when you look at a body, again, just to refresh, you start with the act, and the act is your principal legislation. So that's your NEMA, your Waste Act, your Air Quality Act, for instance. Then your body has arms and legs. Now, if you think about it, your body can operate without arms and legs, right? So arms and legs are what we call subordinate legislation. So it is subject to the act. It's not a standalone. An arm doesn't work if it's not attached to a body. So a regulation is always going to be subject to a particular act. And in this case, NEMA, or the Air Quality Act. So each one of these acts will have its own regulations. And then the last thing is the hands and the feet. Now, when you look at hands and feet in environmental law, you'll see there's a waste management license or an air emissions license or a water use license or an environmental authorization that you might have to get. Now, all of those have conditions. Those conditions become an extension of the law. So when we talk about your compliance, not just do you have to comply with the act or the regulations, but you also have to comply with the conditions of any permits or authorizations that you might have been issued. And then in environmental law, especially the acts that we're going to be looking at, from a waste management, air quality, and your NEMA, the Department of Fisheries, Forestries and Environment issues norms and standards. So basically there's a process where they would, under the Act, issue you with norms and standards, which then become an extension to the law. So norms and standards would tell you what the minimum requirements are. So for instance, if you're looking at organic waste composting, under the Waste Act, there's norms and standards specific to organic waste composting. So you don't need to get a permit to do it, but you have to at least comply with the norms and standards, with the magic word being comply. So in other words, when we're talking about your compliance, you have to comply with the Act as applicable. If there are regulations, and all of these acts have regulations, the regulations that apply, then your norms and standards, then your permits and your authorization. So when you talk about your compliance, you need to comply with the whole body of law. To make things a little bit more tricky, in South Africa, we've got law on 3 different levels. We've got national legislation, we've got provincial legislation, and we've got local legislation. So national legislation, this is what I've been talking about. It's your NEMA, your National Environment Management Act, your Air Quality Act, your Biodiversity Act. Those are your national acts. Then we get provincial legislation. Now, from an environmental perspective, the biggest applicability of provincial is going to come in with your conservation acts. So that's going to be from your protected species, your all of those plants and trees and that are protected that you may not just clear or sell, where you need specific permits for it. That typically falls under your provincial legislation. So you're going to have to go and look at your provincial requirements, the province that you are in, to see if there is any provincial legislation, and then local bylaws. So from your wastewater and your waste management bylaws and your water use, even your air emissions, your national legislation makes provision for your permit, but your local legislation, your local authority actually has the authority to issue those permits, for instance. So at local council level, we should have, depending on your local council, of course, you should have waste management officers that work in terms of the local bylaws that are informed by the national legislation, air quality management officers, so it gets a little bit more specific. So you can see in the upside down pyramid here, national is the broad requirements, provincial is more specific. In other words, it's specific to the province that you are in. And then you've got your local, which is very specific. Now, what you'll see in terms of a system is that the legislation tells us what to do. Now, we as the organization, we need to decide how are we going to do this. And that then brings us to the tip, which is self-regulation. Now, self-regulation, that's going to be your procedures, your internal requirements. So, you'll have I'll show you today what Section 30 of NEMA says about incident management. And then you're going to take that and you're going to have your incident management procedure. So the Act tells us what to do, manage incidents. Then the self-regulation or the procedure tells us how we're going to do it. You'll see, we'll talk about management of change. Section 24 of NEMA says you may not commence certain activities unless you've got an authorization to do so. So the Act tells us that, and then the self-regulation says we have a management of change procedure that says when we are planning a new activity, we first need to go and see, do we need to get that environmental authorization? So how this works is we enforce it from the top down. So what I mean is if your self-regulation contradicts your national legislation, the national legislation will be the stronger one of the two. So you'll have to align with national, provincial, and local in your self-regulation. So it's enforced from the top down, but when you implement from the bottom up. So what that means is if my procedure is stricter than the national legislation, so it doesn't contradict it because then we enforce from the top down, but it is stricter than the national legislation, then I'm going to have to implement from the bottom up. All right, if that makes sense to you. So now, what have I said? I've said when we look at the law, we look at the Act, we look at regulations, we look at norms and standards, permits and authorization. But we don't just look at law on a national level. We have to look at law national, provincial, local, and then our self-regulation, which would be our procedures. Now, if you go to for your procedures, that's where you're going to go to your system. Your system is where you put all these procedures together based on the law, and your system then is the vehicle you use to drive this compliance. So if we use that as the backdrop, let's understand the legislative hierarchy for environmental compliance. Now, my focus for this discussion is going to be 3 levels of legislation here. So when I say levels of legislation, each one of these that I'm going to talk about now are national acts, all right? So you still have to go and fill in the blanks on the provincial and the local as applicable. Of course, if you have a legal register, this should already be in your legal register for you. So because it's, when I say access the legislation, it's not impossible, but it's not as easy as just typing in, give me all the legislation, and there you go. Here's a list of all the legislation. So it requires some legwork. I always say when you're working with environmental law, you have to put your thinking cap on. Right, so let's look at the starting point of when we're looking at environmental law. At the top, we have the Constitution, but not the whole Constitution. The focus point of the Constitution is section 24. So if you look at the Constitution, we say section 24, and section 24 because it is your right to the environment. Okay, so now when we're looking at this, section 24 of the Constitution says everyone has a right to an environment that is not harmful to their health and well-being. And everyone has a right to have that environment protected for the benefit of present and future generations. How? Through reasonable legislative and other measures. Now, those reasonable legislative and other measures, that's all these bodies of law that I've been talking about on a national, provincial, and local level. All right? What must these laws deal with? It must deal with preventing pollution and ecological degradation. That's our focus point for today, preventing pollution, right, and ecological degradation. Secondly, the legislation must deal with promoting conservation. And then lastly, if you've ever heard in the King report, you've heard about corporate governance and the triple bottom line. This is actually a reference to that. If you look at it, we must secure ecological, sustainable development. And how do we do so? And the use of natural resources while promoting justifiable economic and social development. So let's break this down. What does section 24 say to us? Section 24 says We have a right to the environment. Who has the right to the environment? Everyone has the right to the environment. What is this right that they have? The right to the environment plus the right to have the environment protected. Who has to protect this environment? The custodian for the environment is the Department of Fisheries, Forestries and Environment. Or previous to this, it was called Department of Environmental Affairs. And before that, it was called Department of Environmental Affairs and Sanitation. And it's the current name is Department of Fisheries, Forestries and Environment. So they are the custodian. So when we say custodian, they take responsibilities for bringing out these laws. In each one of the acts, you'll see it talks to cooperative governance. So it's not the department alone. They have to work with other departments, but they are the key custodian. All right. Now, if they're the custodian, on whose behalf do they have to protect the environment? Present generations, that's us. So it's the short term, but not just present generations. So, and that's the thing with environmental law. We don't just look at the immediate impact. We also have to look at the long-term impact because we have to protect the environment for future generations, for the long term. So present generations, short term, as well as future generations. Now, how are they supposed to do this? Through reasonable legislative and other measures. What must these laws deal with? They must deal with preventing pollution, promoting conservation, and sustainable development. With preventing pollution, and you could actually say preventing pollution and degradation. We should actually put degradation in there as well. Preventing pollution and degradation, promoting conservation and sustainable development. All right. So now what is the sustainable development again? If you remember that triple bottom line that I was talking about. So to make it easier, basically you have to balance your environmental, your economic, and your social responsibility. To make it easy to understand or remember, we can use people, planet, and profit. So basically we start with planet. That's environmental and ecological. We have to find a balance between planet, profit, which is your economic, and people, which is your social responsibility. So if you know, when we talk about the bottom line, that's profit. But since 1989, when we started looking at sustainable development, it was said that you can't just look at your profit at the end of the day. You have to balance your considerations of profit with your responsibility towards the environment and towards the people. So that's why for our development, and this is critical in a developing country like South Africa, for our development to be sustainable and in line with our constitutional rights and responsibilities, it needs to balance people, planet, and profit. All right. So that's the Constitution. So now when we look at this environmental law family, we at the top of the environmental law family, we have the Constitution. So in our family, you know, we talk about Mother Nature. So we're going to talk about the female role players, the matriarchs in our family. So our grandmother in our family of law, that's the Constitution. So she's the one who started this whole family of ours. Section 24 of the Constitution, the right to the environment. Step number 1. Now, step number 2, we look at the mother legislation. So the mother is more hands-on. That's the day-to-day, and the mother covers everything. So when we look at the mother legislation, that's going to be NEMA. Now, NEMA is the acronym for National Environment Management Act. And it's actually ironic because it's got the word ma in it. So you could actually associate with it, right? You think of a mother, you think of a ma, there we go, there's your NEMA. All right? So that's your National Environment Management Act. Okay. So now the mother, when we look at this, if you look in the act, if you see this little symbol in the left top corner with the, it looks like a dictionary that it's holding with a magnifying glass, this means it's a definition. So in NEMA, section 1 of NEMA gives us a definition for NEMA. It says, when we talk about this act, it includes schedules and regulations and notices issued. So now I want you to think back to the body of law. Remember when I said to you, we're not just going to look at the act, we have to look at the regulations, the notices, the permits, the authorizations, the norms and standards. So basically the definition of this act says the same thing to you, just in different words. So just remember, for me, I find it easier to remember it by thinking about the body of law, right? So basically, when it says this act, it's referring us to the whole body, everything issued in terms of the act. So now we have the grandmother, which is our section 24 of the Constitution, and we have NEMA, the National Environment Management Act. And we see NEMA as umbrella legislation. Now, have you ever heard the saying, I know as a mom, I say this a lot, my house, my rules. Now, NEMA has got the same thing. So NEMA says in the National Environment Management Act, there are certain things like incident management and Section 28, duty of care. We're going to look at those today. And even Section 24, your environmental impact assessment. You find those rules and your penalties and offences clauses and your Section 34 of NEMA that deals with additional fines that the state can award against you. All of those rules we find in NEMA. So they apply to NEMA, which is the broad National Environment Management Act. So it covers all environment. So this umbrella covers everything relating to environment. But the requirements in NEMA apply to the environment, but it also applies to everything under NEMA. So we have the grandmother, which is the Constitution, and NEMA, which is the mother. Now, you'll see our mother has 8 children, and we call those SEMAs, Specific Environmental Management Acts. So in other words, the provisions that we find in NEMA will also apply to all of these SEMAs. So it doesn't have to be repeated in the SEMA, but it is still applicable to the SEMA. So it covers anything under the umbrella is covered by the provisions in NEMA. I know it's a lot. So you guys, I'm hoping that this is making sense. If it feels a little confusing, bear with me. I'm walking us towards the bigger picture here. So, right, I've said in our environmental law family, we start with the Constitution, section 24, then we look at NEMA. Our focus for today, the sections that we are going to be looking at will be coming from NEMA, which would be our umbrella. And then the last level is going to be the SEMAs, SEMA. So SEMA is the acronym for Specific Environmental Management Act. So in other words, these acts deal with something specific. It's not general, it deals with something specific. So what do we find in the under Specific Environmental Management Act? We have the Environment Conservation Act. So you'll see on slide number 18, this is the explanation of the different acts. And then I just want you to have a quick look here at the bottom. I'll go through the list just now, but at the bottom of the definition of Specific Environmental Management Act, it says, and it includes any regulation or other subordinate legislation made in terms of these acts. So we go back to the body. So it's not just these acts. You have to look at these acts plus the regulations, the norms and standards, the permits, the authorizations in terms of these acts. So now what do we have? We have a platform for environmental law. This can be our starting point for environmental law. So if we go to our body of law, we look at the Constitution, we look at NEMA, and then we look at CMAs. So the strange one in the picture is, of course, the Environment Conservation Act, because technically the Environment Conservation Act actually was NEMA's predecessor. So before we got NEMA in 1998, we actually used the Environment Conservation Act. But NEMA then in 98 replaced the Environment Conservation Act, most of it. We still had some issues relating to waste that was under the Environment Conservation Act. And then in 2008, when we got the Waste Act, you know, that actually repealed most of the body, the part of the act in the Environment Conservation Act. So then I've got, sorry, I don't know if it's just me, I have some disturbance. Do you hear that as well? Can you guys just check for me that you've muted yourselves, please? I don't know if I'm able to mute everyone. Let me see if I can do it. Wait, sorry, Gerard, I'm going to mute you now. There we go. Sorry about that. There's a function to mute everyone. I hope you don't mind. Sorry, Gerard, you can just unmute yourself again.
Yeah, so I muted everyone, so I think
okay,
we're
you
good
also
to go.
did.
Yeah,
Okay,
I'll
all right.
just have a look out. Thanks, Lucinda.
Okay, thanks. Sorry about that. All right, so if we get back to the Environment Conservation Act, if you're going to look for something to comply with under the Environment Conservation Act, you'll see I've highlighted the arms and the legs. Most of what we use today under the Environment Conservation Act actually relates to the regulations. Like, for instance, the plastic bag regulations. You know, when you go and do your shopping, and you buy groceries and they ask you, would you like a bag? And then you have to pay for that bag. That's not just a money-making racket by somebody. There's actually plastic bag regulations that require that. That comes from the old Environment Conservation Act. So very limited scope, but it is still there. Then our next CMA is the National Water Act. Now, interesting with this one is water is managed by the Department of Water and Sanitation. So they are one of the government departments that we require cooperative governance with between the Department of Fisheries, Forestries and Environment on environmental issues. So when you're looking at your water use licenses, that's going to come from the Department of Water and Sanitation. It falls under NEMA, so it's part of the One Environmental Management System, but the department directly responsible for the National Water Act is Department of Water and Sanitation. You can see it's also a 1998 Act, so it basically is same time as NEMA. And what I've done here is I've just put I set you with CMAS, Specific Environmental Management Act. It deals with a specific issue. So your specific issue here is going to be, or your specific aspect here is going to be water. Next one is the World Heritage Convention Act, a 1999 Act. You'll see when we look at the definition of environment, it includes cultural heritage or the cultural aspects of the environment. So that's why your cultural heritage is included, your World Heritage Convention Act. Next up, we have the national. Now, the next ones, the rest of these CMAs, they're easy to identify as CMAs because they all have the same prefix. National Environment Management Protected Areas Act, National Environment Management Waste Act, National Environment Management Air Quality Act. So these are the ones that came after NEMA, and they're easier to identify as being part of NEMA or the CMAs for that matter. So we start with the Protected Areas Act. This is where, in terms of this act, certain areas based on its environmental sensitivity will be declared under the act as a protected area. And because it's a protected area, you'll have additional rules and requirements that would apply because of the environmental sensitivity. 2004, we got the National Environment Management Biodiversity Act. It deals with your biodiversity. So we're looking at protected species, protected plants, protected animals, protected trees, invader species, invader plants. All of those requirements would fall under the scope of biodiversity. Then in 2004, we got the National Environment Management Air Quality Act. It replaced the old Atmospheric Pollution Prevention Act. So we got the Air Quality Act. For me, this is the most difficult one of all of these acts, because if you go and look at the act itself, you're not really going to find your responsibilities listed in the act like you would do with NEMA, for instance. Most of what you're going to have to do in terms of this act, greenhouse gas inventory, all of those requirements actually come from the regulation. So what you'll see with the Air Quality Act, it deals a lot with institutional and planning matters. So technically it tells us what the duties and responsibility of government is, and then they bring out ozone depleting substances regulations, right? So if you do have ozone depleting substances, you're not going to find what you need to do in the act itself. You're going to find what you need to do under the regulations that were issued under the act. The same with greenhouse gases. If you do have greenhouse gas emissions, you're not going to find your requirements in the act itself. You're going to find it under the regulations, or if you have small scale boilers, for instance. So that's a boiler for which you don't need an air emissions license. The emissions requirements for your small scale boilers, you're not going to find it in the act or the regulations. You're going to find it under the norms and standards that were published under the act. So for your Air Quality Act, for me, I think most of the responsibilities you're typically going to find in your subordinate legislation. Then in 2008, we got the National Environment Management Integrated Coastal Management Act. So it deals with coastal issues. So that's basically where the ocean and the land meet. That's your coastal area. It's only going to be applicable there. So if I'm inland, then this legislation is not going to be applicable to me. But if I need a water use license and I'm in a coastal area, I'm still going to need the National Water Act for that. It's not going to be your Integrated Coastal Management Act. And then the last of the CMAs that we look at is the National Environment Management Waste Act. Critical for us, right? Waste management, all of our waste management efforts, the Waste Act and the regulations under the Waste Act, and the norms and standards. There's a whole bunch of norms and standards. That's from composting your organic waste, shredding or baling your general waste, your waste classification, your waste inventory, your waste registration, all of those. There's a whole bunch of regulations under the Waste Act that we're going to have to look at. So when we look at the bigger picture, this is now my family of law. Like I've said, you start with the Constitution, Section 24 specifically. Then we look at NEMA, and NEMA is the umbrella legislation. So everything that's in NEMA will apply to NEMA as well as to all the CMAs. CMAs are Specific Environment Management Act. So that's all of these. These are all of your CMAs. And you will remember that it's the Act and any subordinate legislation issued. So that's why we've used the bodies. It's the regulations, the arms and the legs, as well as the norms, the standards, the permits, the authorizations issued in terms of those acts. Again, word of caution, this is the national family. So we have to add onto our family cousins and distant cousins, and those are going to be your provincial and your local requirements. Don't forget about provincial and local requirements as well. All right. So basically, if we look at it, the critical part here of all of this, the pivotal part of environmental law is going to be NEMA, the mother legislation, the National Environment Management Act. So if you look at this act, I think when you're looking at compliance, you need to go and look, as you do with any legislation, you need to take the act and you need to filter it, and you need to say, what of this is going to be applicable to me and what is not going to be applicable to me. So Section 2 of NEMA is your 7 environmental management principles. That's definitely going to be critical for us to look at. I think Section 23 and 24, Chapter 5, that's going to be quite important, because when you're looking at chapter 20, at chapter 5, section 23 is integrated environmental management, and then your EIA process, that falls under chapter 5. Then if we go and look at chapter 7, that's definitely key for us to look at. That's going to be your section 28, duty of care. We're going to look at that. There's your section 29. You've got your protecting your environment, your employees refusing to do environmentally hazardous work. Section 30 is your environmental incidents. Section 31 is your protection of your whistleblowers. Section 31A to Q, that's going to be your environmental management inspectorate, the green scorpions. And then, of course, 32 to 34, that's going to be your offenses, penalties, your legal standing, those clauses. Those are going to be key for us to look at. And then, of course, section 49A and B is your offenses and penalties clauses. We need to look at those as well. So that for me would be where the key components lie when we look at NEMA. All right, you guys keeping up with me?
Yes.
Okay,
Thank
good.
you.
Now, our next question. So that was our first question, right? Our first question was, what acts and regulations do I look at as a SHEQ practitioner? I think I've given you a broad framework to look at. It becomes quite tricky if you don't have a legal library to access to look at this. So you might want to look at putting together something like that, or enlisting external services to assist you to put that together. If you're going to go for any formal system like an ISO 14000, you are going to need something along the lines of the simplified reference is legal register, but basically a company specific law book to show that you have enlisted a process of identifying what laws, national, provincial, and local apply, how do they apply, because that's what your compliance will be measured against. All right, I'm checking. Right, did you see the note that you need to remember to register there? I think the registration can also be important. Gerard, are we going to share the presentation and the extra documents?
Yes.
After? So
Yeah.
if you don't register, you won't get the copy of the presentation and the extra documents, right?
Yeah. So we are going to distribute the presentation as well, and Annalyn usually share the recording as well.
Okay. Yeah. So guys, that makes the registration even more important. Right. So now our next question that we have to answer is, what is the, now we've done what is the layout of NEMA, your fines and liability when it comes to environmental non-compliance or environmental factors. Now I can go into section 49A of NEMA and tell you what the offenses are, and then I can tell you what the penalties are. Basically, offenses and penalties in the environmental law work on a first offense or some less serious offenses, 5 million or 5 years or both. And then for your more serious offenses or your repeat offenses in some of the CMAs, 10 million or 10 years or both. But I'll admit those are high fines, and it makes it a lot easier when I'm doing training or trying to convince somebody to comply with the environmental legislation, because I can say, right, look at this. This is how the penalties work. But what I'd rather like to discuss with you is something that I find really valuable that comes from the Department of Forestry, Fisheries and Environment. For the past 16 years, 16 years, right? For the past 16 years, they have every year issued something called a National Environmental Compliance and Enforcement Report. So what they do with this compliance and enforcement report is they basically tell us, right, this is what we have done with regard to compliance and enforcement. So although the penalties sit at a maximum of 10 million, it's not necessarily going to be 10 million. So what I find in looking at the court cases, because each one of these court cases, actually that they list court cases in this report. They tell us that this is the fine, so this is the fine in terms of the act, but then they add the section 34 component. So section 34 of NEMA is basically the polluter pays principle. So what happens here is section 24 says, in addition to any fine that you might have to pay for non-compliance, the court can, in the same proceedings, order that you clean up and rehabilitate, that you pay for the cleanup and rehabilitation component. So that's where the big money comes in, because now we're looking at cleanup and rehabilitation. So what they would do is they would give you R1 million or a 4 million rand fine, and that's the money that goes, or a 5 million rand fine, and that's usually suspended. That's the money that would go to the state in terms of the act. So that's your section 49 capital B fines in NEMA, for instance. But then they make specific payment orders. Now, the specific payment orders is for cleanup, rehabilitation, and other expenses. So that's going to be in terms of section 34. So if you're interested in this, you can have a look. One of the documents, there's 2 additional documents that I've shared that will be available to you, is number 1, your National Environment Compliance and Enforcement Report, this one, and then I've put a guide on administration. If you're interested in these reports, you'll see when you look at this report, you're going to see that they have they cross-reference previous reports. So if you are interested in the previous reports, you'll see my email address is in this document, but you can also, I'll put it in the chat now. Johan Botha, I think you asked, why is your ID number required? It helps to identify the person. We need the same thing for certificates as well, because if there's another Johan Botha, we need to make sure which Johan Botha is this going to be. Is it the one from Vereniging or Pretoria? So that's why ID number is your most unique identifier, if that helps. All right. So if you look at the NERSA report, as I said, it is available. I just want to give you an idea on for the year 2022-2023. So this is what they tell us on compliance. So this will give you an idea. So they also in this report tell us how many inspectors they have and in which departments the different inspectors are. But if you look at this, for instance, they say to you, right, in the 2021-2022 year, they visited 4,171 facilities, and then in the last one, it was 4,333. So those are their proactive visits that they went to. 52% of the facilities inspected, they were looking at waste and pollution. 42% was biodiversity, and 6% was your oceans and coastal related. What triggered it? They had permit or authorization inspections, and then reactive inspections. So reactive inspections would be if there was a complaint or they were following up on an incident that was reported. Then you can see what they do is they break it up into brown issues, which is your pollution and your waste, blue, which is your oceans and coastal related, and green, which is your compliance requirements. And then I say to you, right, what is the number of non-compliances that were detected. Now you can see in the past year, there was actually an increase in the non-compliances. So in the reactive inspections, there was also a decrease in the reactive inspections compared to the previous year. Now let's go to what the question was actually all about. Fines and liability when it comes to environmental. So instead of just throwing you with it can be 10 million, let's see what happened. So the number of admission of guilt fines. So an admission of guilt fine, how it works, right? You can see that there was in the past year 1,211 admission of guilt fines. That's where you pay a fine instead of a criminal prosecution. How many criminal dockets for non-compliances? 359 court cases. A lot of these court cases actually deal with your conservation. There's a lot of conservation issues. Illegal rhino hunting, your protected species and all of those. There is quite a number of those cases there. How many arrests were made? 662. How many acquittals? So acquittals is where they go through the process and then they were acquitted. Now, 24G, this one over here in the right-hand corner at the top, that's an admin fine. So what happens with the 24G is, as I've already mentioned, for certain activities, you may not commence the activity unless you've got an authorization. So there's certain lists in the regulations. There's a list under the National Water Act with your Section 21 list of activities that require a water use license. Then you've got under the Air Quality Act, under the Waste Act, and under NEMA, specific lists. Now, if you commence that activity without an authorization and you become aware of the fact that you've done so, Section 24G makes provision that you can do an application for condonation of the fact that you commenced. Now, part of that application for condonation is that they can issue you with a fine of up to 5 million rand, an admin fine that you'll have to pay, and you'll have to do an after-the-fact environmental impact assessment. So you can see from the fines there, they don't typically go straight for 5 million rand. They'll give you a portion of 5 million rand. So how they decide on the amount that you're going to pay for that fine, there's actually under NEMA a regulation, right, that says how they are going to calculate the fine. Right, so you can see there, but it did increase the amount of fines paid for your 24G applications. So if you look at your plea and sentencing agreements, there was an increase in your plea and sentencing agreements. There was a decrease in the admission of guilt fines paid in 2023. So I suppose that's a good sign from a compliance point of view. The notices, the admin notices that they issued was not substantially, but still there was a decrease. So you can see it looks good from a compliance comparison point of view. So when you're looking at this kind of report, you can go, each of the acts has a clause called penalties and offenses. So for something to be an offense, the act needs to tell you what the offense is. So it'll say to you, right, if you fail to do the following things, that's a criminal offense, criminal offenses, of course. And then it gives you penalties relating to that. And the penalties range between 1 million, 5 million, 10 million, and then usually 1 year, 5 years, 10 years, depending on which one of these, the NEMA or the SEMA, you are looking at. For me, it makes more sense if we can see it in working, and that's where this report comes in. All right. Right, anyone that wants to see more on this, as I said, you can look for this National Environment Compliance and Enforcement Report. This one, the 2022-23 one, I have included in the pack. And I do have a whole folder with all of the previous reports. What I like about the reports is, for instance, I just want to show you quickly, just a quick look, and then I have to move on. Let's see if I can just bring it over to the view that you see. No, let's try it here. For some reason. Let's try. There we go. That's the actual report. Now, I've only shown you a little bit about this, but if you just have a look at this, they give you a lot of statistics, environmental jurisprudence, that's the court cases. Something else that I like, they tell you what changes they have made on these particular acts. So those are you see NEMA and your CMAs, those are the changes that you see. And then what changes are they, this is nice, the prosecution of environmental offenses. And then what are they planning for the next year? So they tell you in advance what changes are we looking at for the coming year. And then National Environmental Complaints and Emergency Incidents. So that's going to be your section 30, reporting of incidents we're going to do. You see that in the report as well. So overall, sometimes it feels like a name and shame, because if you look at the court cases, this is now your example of the court cases where they discuss specific environmental court cases. That's your legislative developments. And then under the industrial compliance, they tell you where they went. So they would say to you, right, we went to Samancor ferrometals, for instance. So I've looked at this, and I've looked to see, here's your landfill sites that they've been to. Your health risk care, waste treatment sites that they've been to. So you might be using some of these sites for your waste management. There's your sugar mills, pulp and paper, that's where they went to, fertilizer and acid generation, smelters and refineries. So there isn't a specific component on agriculture at this moment. They do have the mines in there, but not on agriculture specifically. And then I always get complaints about the municipal land sites and the failure of compliance there. So you can see some feedback on that. And then, of course, more specific issues. So overall, when you're looking at answering the question as to fines and liability, I would go to the National Environment Management Compliance and Enforcement Report. Right. So let's move to our next component. When I started off, I said to identify the law, you need to understand what your environmental risk is. So is there like a winning recipe? How do I do an environmental risk assessment? I haven't found it yet. If I do come across it, I will share it wide. But for me, environmental risk assessment, you need to understand where it comes from. And then it's going to be self-regulation. So you're going to have to do this yourself. But to do it, if you understand what the law says, and I've also included here a little bit of a discussion on what your ISO 14000 environmental management system says. Hopefully this will guide you in the right direction. So how do I conduct my environmental risk assessment? What are the key factors that I look at? So step one, if you want to do an environmental risk assessment, do you understand what is the environment? What do you have to look at when you're looking at what is the environment? So the environment that must be protected. How do we know what this environment is? Because your idea of the environment and my idea of the environment might be two different things, right? So for that, we go back to definitions. So we start in NEMA section 1. And in NEMA section 1, there is a definition for the environment. So what is the environment? It is the surroundings within which humans exist that are made up of land, water, and the atmosphere of the earth. Microorganisms, plant, and animal life. It's any part of the above and the interrelation between them. It's the physical, the chemical, aesthetic, and cultural properties. Do you remember I was saying about cultural heritage? The World Heritage Convention Act is included because cultural heritage is part of your definition of environment. That's where you see it. Physical is easy to understand. Chemical is easy to understand. Aesthetic, it's the visual impact. It's what you see. That's basically aesthetic, and cultural properties and conditions of the above and the influence that it has on human health and well-being. Yes, you're right. Gerard, you're right about the environmental risk assessment for your pesticides or other chemicals. For me, if I was making use of a pesticide, Gerard is saying that the environmental risk assessments for pesticides or other chemicals are extremely complex studies, calculations, and modeling. From my point of view, if I'm on site and I'm looking at what the risk is associated with my pesticide, I'm of course going to look at my safety data sheet as my starting point, because it's a legal requirement that I should have that. So that would be my step number one, that I'm going to look at. Right. So if we look at this definition of environment and we break it down, what is the environment? It's the surroundings within which humans exist, that is made up of land, water, and the atmosphere of the earth. It includes microorganisms, plant life, animal life, and any part of this and the interrelation between it, as well as the physical, the chemical, the aesthetic, and the cultural properties of this, and the impact it has on human health and well-being. All right, so that's the environment. Good. Now we need to protect the environment, and we need to prevent pollution. Do you remember the Constitution section 24 said we need legislation that prevents pollution, protects the environment and prevents pollution. So what is pollution? Right, again, we go back to definitions. So NEMA section 1 says the definition of pollution. So pollution is any change in the environment that is caused by substances, radioactive or other waves, and noise, odor, dust, or heat emitted from any activity, including storage or treatment of waste or substances, and the construction and provision of those services, whether it is engaged by the state or a person. Okay, so it's any change in the environment that is caused by substances, radioactive or other waves, noise, odor, dust, or heat emitted from any activity where that change. So firstly, we need to determine, was there a change? Now, secondly, did that change have an adverse effect on human health or well-being, on the composition, resilience, and productivity of your natural or managed ecosystems, or on materials useful to people, or will it have such an impact in future? So not, you remember when we were looking at this, when we were looking at protecting the environment, we have to protect it for the present as well as the future generations. And there you see the reference to future pulling through again. Now, let's break it down. What is pollution? It's any change in the environment that is caused by substances, radioactive waves, other waves, noise, odor, dust, or heat emitted from any activity where the change has an adverse, negative effect on human health or well-being, the composition, resilience, or productivity of your natural or managed ecosystems, or might have such an impact in future. So we got that. Next step. What is integrated environmental management? Now, basically, integrated environmental management is not integrating it with your health and safety system, right? I often find when we talk about integrated systems or integrated management, the first assumption is, yes, we have to integrate environment with health and safety. I understand that you have integrated systems, but what we're talking about here is a little bit more complex. And that is section 23. So if you look at the screen now, you'll see I've put NEMA section 23, integrated environmental management. So under section 23, NEMA says we need to promote the integration of the principles of environmental management into the making of all of our decisions that might have a significant impact on the environment. So of course, now we have to go back to section 2. So you'll see I've got a reference to section 2 in there. Now, guys, if you go and read section 2, it doesn't have principle 1, principle 2, principle 3 stipulated like I've got it here. It's a you read it, and for me, sometimes when I read it, it feels like they've taken the same thing and they've just reversed the words around in some issues. It feels like a lot of repetition. So over the years, what has happened is, in working with section 2 of NEMA, we've come up with certain principles and we've gone and typed these principles. So as it stands, we can identify 7 different principles in section 2 of NEMA. Now, what section 23 says is you have to. So when you're looking at your environmental management and your decision making that might impact on the environment, you need to be able to show that you have integrated all of this into your decision making procedures. All right, so what are these principles? The first one we've already looked at, sustainable development. That's when we look at people, planet, profit. You remember the triple bottom line. When you make any decision, you need to be able to show that the decision you made is the best practicable environmental option. So the option that causes the least damage to the environment as a whole, but is the most beneficial for the environment. Then precautionary principle. Basically, with precautionary principle, when you're making a decision and you cannot to a degree of certainty say this is going to be the impact, you have to assume worst case scenario. A good example of this is always waste. Because if you find a bottle and in the bottle there's a green substance, but you know that's not the substance that's supposed to be in the bottle. If you cannot tell me to a degree of certainty what that is, you have to assume that it's hazardous waste. So it can't go into your general waste. Or, you know, when you sort your waste and you've got your paper in one bin and you've got your oily rags in another bin. And somebody went and took one oily rag and put it in your paper bin. And now the environmental people say to you, lots of drama, you have contaminated the entire waste stream. And you think to yourself, but why? It's because of the precautionary principle, because unless you can prove that you have not contaminated that entire waste stream, you have to assume, so you must to a degree of certainty be able to say that you haven't done that. Otherwise, you have to assume the worst case scenario, and that's your precautionary principle. Then we look at your preventative principle. So easy to understand, prevention is better than cure. So you need to avoid pollution and degradation of the environment. And if you cannot altogether avoid it, you need to minimize it and remedy the negative impact that you have caused. So that's number 4. When we look at cradle to grave, it's basically your life cycle responsibility. And you'll see in environmental risk assessment under ISO 14000, you'll see that they've got a reference to life cycle as well. Cradle symbolizes beginning. Grave symbolizes end. So your responsibility is from the beginning to the end. Waste, again, is a very good example, because when does your responsibility for your waste stop? The moment that your service provider takes it off your site, can you then say, oh, well, good riddance, no longer my problem? Or is it only once they've disposed of it in an environmentally authorized and responsible manner? We would like to say when it leaves our site, but according to the law, that's not the case. You are responsible until that waste is properly disposed of. So if it ends up in an unauthorized site, you can still be held responsible because you did not manage your waste properly. Then Polluter pays. I've talked a little bit about this when we were looking at the penalties clauses. If you remember, I said, in addition to the fines and imprisonment that you find in your offences and penalties clauses in your act, there is also in NEMA specifically section 34 that says you have to pay for cleanup and rehabilitation. And that's polluter pays. Right? So you pay, the one who polluted will pay to clean it up, not just the penalties, but you'll pay to clean it up. The impact it has on the environment as well as human health, immediate impact as well as delayed impact. And then last year we got an amendment to a whole bunch of the environmental laws, and we got a new addition to section 23, and it says when you're doing your public participation process, there is an importance of inclusive participation. So that's in your EIA process. You have to make sure that you also consult with your indigenous knowledge practitioners. All right, so basically, when we look at environmental management, it needs to be integrated. So we have to look at all of these principles. But how does it work? How do we translate that? So we've said people, planet, profit, right? We got that. So what do we do now? What's the next step? We look at energy, we look at air, we look at water, soil management, plants, and animals. Still, there's a few gaps, right? So how do we work that? Remember, we're looking at risk assessment, right? Our aim here is to understand what all we need to look at when we're doing risk assessment. So under energy, efficient use of energy and alternative energy. Under air, we need to try and improve our air quality and avoid greenhouse gases and things like ozone depleting substances in line with the applicable legislation. Efficient and responsible use of water. So that's we don't waste water, we don't contaminate water. If we contaminate water, we clean the water. That's what we're looking at under water. Soil, we need to enhance and sustain our soil fertility and improve our pest control techniques. Under plants, conservation and sustainable use of biodiversity. Animals, ensure animal welfare, wildlife diversity, and again, conservation. All right. So, okay, so now we have to integrate all of this together with our 7 environmental management principles. For me, I want to add on to this section 28 of NEMA. If you make a decision, if you go and look at my day-to-day responsibility for the environment. If you ask me, what section would you use for day-to-day responsibility? I would go to section 28. Section 28 is your general duty of care. So section 28 says to us, every person who causes now, has caused in the past, or may cause significant pollution or degradation of the environment, must take reasonable measures to prevent the pollution or degradation from occurring, continuing, or reoccurring. All right, so if I cause pollution, now we know what pollution is and we know what the environment is. So if I cause pollution, if I have caused pollution, or if I may cause pollution, I must take reasonable measures to prevent the pollution or degradation from occurring, continuing, or reoccurring. Insofar as harm to the environment is authorized, that means you've got a waste management license, air emissions license, a water use license. By law, so right, it's authorized or cannot be reasonably avoided or stopped. Do you remember avoid, minimize, remedy? You need to minimize and rectify that pollution or degradation. That's our starting point. Every person who causes, has caused, or may cause. So if we're looking at this, this is quite wide. So now it makes sense that we ask who must make sure of this. Now, section 28.2 then tells us, without limiting the generality of the duty, the persons on whom this obligation is imposed includes the owner of land or premises, the person in control of the land or premises, or the person who has the right to use the land or premises. So in other words, owner and or user and or controller. Owner, user, controller of the land on which an activity or process is or was performed or undertaken, or a situation exists that causes, has caused, or is likely to cause significant pollution or degradation. So in other words, it can be one or the other or all three, especially if you have different role players. This is very important because it expands the responsibility to different entities. Okay, so now owner, user, controller needs to take reasonable measures. So what are these reasonable measures that we need to take? Let's see. Investigate, assess, and evaluate the impact on the environment. And for our purposes, that is your legal requirement for an environmental risk assessment, because you need to investigate, assess, and evaluate the impact of your activities on the environment. So environmental risk assessment, if you go back to your workplaces and you look at your impact and aspect register, that's basically your environmental risk assessment. All right, the impact that your activities have on the environment. And then in addition to that, you need to inform and educate your employees about the environmental risk of their work and the way that they must perform their tasks to avoid causing significant pollution or degradation to the environment. So you need to train your employees on the environmental risks. Once you've done the environmental risk, the employees need to be trained, much like your health and safety legislation. By the way, when we do environmental risk assessments, the environmental legal compliance audits, this is typically where we find areas of non-compliance. Okay, then you need to cease, stop, modify, or control any act or activity or process that is causing the pollution or the degradation. You need to contain or prevent the movement of the pollutants or the causant of the degradation. You need to eliminate any source of the pollution or degradation, and you need to remedy the effects of the pollution or the degradation. So stop, avoid. Do you remember avoid, minimize, remedy? You see that in here as well. From cease, modify, or control. If you go back to your workplace and you look for something called a spills procedure, how do you handle your spills? Let's say you had a diesel spill. You'll see you've got a spill kit, and then you have to stop whatever is creating the spill. And then you need to, from the spills kit, you take that absorbent material and you put it on top to avoid the movement of the pollutant, and then you clean that up, right? It's basically what we see the point 3, 4, 5, and 6 there. It's the starting point of a spills procedure as well. It doesn't say spills procedure, but that's what you use as the foundation for your spills procedure as well. So it's a very basic principle, but when we talk about your duty of care starts with knowing what your environmental risks are, training your employees, and then managing that environmental risk. Now,
Lucinda, sorry, I just want to interrupt you there quickly and just remind you on the agenda, we just have a body break at 10:30.
I've got that, yes.
Cool.
I've got that. I'm working towards that.
100%.
Okay. Don't worry, I'm very aware of the time. You know, I usually take about an hour and a half just to introduce myself. So I'm very impressed that I've cut down on that part today. Okay, thanks, Gerard. So the next step you need to do is you need to look at applicable environmental aspects and impacts. So for this, it's important that you understand, why are you doing an environmental risk assessment? Are you doing it because it's part of an environmental impact assessment process? Remember that section 24 where I said before you can commence the activity, you need to get an authorization. In that case, the prescribed requirements, the legal requirements for that is that you're going to appoint an environmental impact assessment practitioner. So environmental assessment practitioner, EAP, environmental assessment practitioner. There's specific rules around that. Then they're going to do this process for you. That's not going to be, this is not the one where you're going to do the risk assessment yourself. If you're doing it to satisfy the requirements of a management system like ISO 14000, then you're going to write your own methodology, but it still needs to meet the minimum requirements of the ISO 14000 system. If you're doing it to be legally compliant, then your methodology for the risk assessment is going to be flexible. So you'll determine it by way of your own procedure, but it must at least be aligned with Section 28, where we find the starting point. So if we look at it, if we look at an example for this, you can look at ISO 14000, right? ISO 14000 is an international system, and it's for environmental management system. And if you look at ISO 14000, it gives you, and what I've tried to do here is just to give you an idea on the terminology and what they require when it comes to risk assessment. So there they say the environment is the surroundings within which an organization operates. It includes air, water, land, natural resources, flora, fauna, humans, and their interrelationships. So if we look at our definition of environment, we got that right. But then you'll see they use terminology like aspects and impacts. So what is our aspects? Our environmental aspects is an element of an organization's activity or products or services that interacts or can interact with the environment. So your environmental aspect can cause an environmental impact. A significant environmental aspect is one that has or can have one or more significant environmental impacts. So your aspect has an impact. Okay, I got that. What is an environmental impact? It's a change to the environment, whether adverse or beneficial, so good or bad, wholly or partially resulting from your aspects. So you need to prevent pollution, which we also found in the law, the use of processes, practices, techniques, materials, products, services, or energy to avoid, reduce, or control, separately or in a combination, the creation, emission, or discharge of any type of pollutant or waste to reduce adverse environmental impacts. Prevention of pollution can include source reduction or elimination, process, product, or service changes, efficient use of resources, material and energy substitution, reuse, recovery, recycle, reclamation, or treatment of environmental aspects. Okay? Okay. And this is life cycle. I talked about life cycle cradle to grave earlier on. In ISO, you also see life cycle. It's consecutive and interlinked stages of a product or service system, from raw material acquisition or generation from natural resources to the final disposal. So from beginning to end, cradle to grave. The life cycle stages include acquisition of raw materials, design,
Lucinda, I think you muted yourself there.
Did I mute myself? How did I do
Yes.
that? I hope it was me and not somebody who had enough of listening to me. Sorry.
I'm sure
The life
not.
cycle stages include acquisition of raw materials, design, production, transport, delivery, use, end of life treatment, and final disposal. Again, from beginning to end, our responsibility is from beginning to end. So basically, in terms of 14,000, it says within the system, you need to determine the environmental aspects of your activities, your products, and your services that can be controlled and influenced, and their associated environmental impacts, considering a life cycle perspective. When determining environmental aspects, you need to consider change, including planned or new developments and new or modified activities, products or services, abnormal conditions and responsibly foreseeable emergency situations like fires or explosions, for instance, dust explosions. That could be part of what you look at there. You need to determine the aspects that have or can have a significant environmental impact by using established criteria. So you're going to need to have a methodology for that. You need to communicate significant environmental aspects among your various levels and functions in your organization. And very importantly, you need to maintain documented information on your environmental aspects and associated environmental impacts, aspect and impact register, the criteria used to determine this, and the significant environmental aspects. Significant environmental aspects can result in risks and opportunities. So you're associated with adverse environmental impacts, which is your threats, or they can have beneficial environmental impacts, which would be your opportunities. So it's not necessarily all going to be negative. There might be positive components, and those are your opportunities. Now, if before we take a breather, I went and I don't do the risk assessments myself, but I went and I looked at a few impact assessments for silos specifically. And I tried to take from the impact assessments that I read what could potentially be. Now, I'm going to be a real lawyer about this. This list is not exhaustive. I'm giving you an idea around what it could be. All right. Typical environmental impacts on an agricultural business environment like silos. That's the last part of question 4. So if we look at it, under air, you've got air quality, gaseous or odorous substances from your fermenting grains, your rotting grains, your fumigants that are used in pest control, fine grain dust. And then if you remember pollution, it included noise as well. So noise pollution, dust explosions, veld fires or other fires. Then under soil, you could be looking at pest and insect infestation and your pest control. Also, you need to, under degradation, look at soil erosion and loss of biodiversity. Then you can look under energy, your power consumption. Under waste, you have different types of waste. You've got your organic waste, you've got your general waste, you've got your hazardous waste. And then, of course, a key element is also water. Water use and water demand, effluent generation, and your water quality. Right, so that would include your water contamination or activities that can contaminate your water. So this would be the typical environmental impacts in an agricultural business environment like silos, according to what I've seen. Again, it's not an exhaustive list. Right, I know that according to the program, we would have already answered, we would already be at question 5. But I think we're going to take our break now. It's a 50, it's a, what is a 15-minute breather, right? Yeah, it's 15 minutes. So we're going to take a 15-minute breather and we're going to start again at 2:45, and then we'll start with question number 5. Is that fine?
That's perfect. Thank you, Lucinda. Just as a reminder for everyone, we are going to send the workshop material through for accreditation for CPD points. So please make sure that you complete the registers. Otherwise we won't be able to register you for the CPD points. So yeah, maybe take the time during the break to do that as well. We'll then commence at 10:45, 10:45 to 11. Thank you.